The Honorable, the Supreme Court.
Good morning. Morning. Thank you all very much. Please be seated. And when you're ready, please call the case.
Good morning, Your Honors. The matter before the court this morning is the case entitled Ann Jackson and Jeffrey Jackson versus Willard Jackson and Willard Jackson as trustee for the William Jackson Trust of 1939 and the William Jackson Trust of 1941. Case number 24 AP 337. Representing the appellants, Ann Jackson and Jeffrey Jackson, is Maureen Sturdivant. Representing the appellee, Willard Jackson and Willard Jackson as trustee for the William Jackson Trust of 1939 and the William Jackson Trust of 1941 is Peter F. Langrock. Seated at council table with Attorney Langrock is Wendy Radcliffe.
All right. Thank you very much. Good morning, counsel. Good morning. Please, appellant's counsel, come on up to the podium if you would. And before you start, please, for the record, introduce yourself and identify your client.
Good morning, Your Honors. My name is Maureen Sturdivant, and I represent Ann Jackson and Jeffrey Jackson.
Thank you.
Thank you. May it please the court. My clients and I are before this court because of Willard Jackson's breach of his fiduciary duties as trustee of Trust 2 and Trust 4. In the Superior Court's error by applying the wrong legal standard by which to assess his conduct, and then doubling down on that error and awarding attorney's fees against my clients. Trust 2 and Trust 4 were established by my client's grandfather, William Jackson, in 1939 and 1941. And they had a straightforward purpose in relatively straightforward terms. They were to provide income to his children during their lifetimes, and then upon their respective deaths, the trusts were to terminate and to distribute all remaining income and principal to William Jackson's grandchildren. The remainder beneficiaries, free and clear of any trust ownership for their own use and purpose. Unfortunately, because of Willard's use and management of the assets of Trust 2 and 4 to so entangle them in a global family asset structure, without court intervention, as it stands now upon trust termination, my clients will not receive their respective trust interests in the manner in which their grandfather.
That's the, and maybe the underlying complaint initially was in probate court, right?
Correct, Your Honor.
Appealed to the Civil Division of the Superior Court. Are your claims in some manner speculative? That's what I want to ask, because your client's interests don't vest until the death of Willard. Is he still alive? Has he passed away?
But my understanding is that he is still alive, Your Honor, and I disagree that the claims are necessarily speculative or premature. I believe the time to bring them is both appropriate, given the fact that you can see the resulting impact. What the trust assets hold currently are foreseeably entangled and will violate the intent and purpose of Trust 2 and Trust 4.
Do the trust documents concerning Trust 2 and Trust 4 require that the assets that are ultimately obtained at the time of the death be liquid or readily capable of being liquidity?
So, no, Your Honor. The trust documents don't require liquid. What the trust requires is that ownership of the trust assets are distributed upon termination absolutely and forever. And as this court is aware, absolutely and forever means free of trust ownership and of sole ownership.
So your claim is entanglement of assets equals mismanagement of trust.
That's a succinct way to distill a complex
factual. That's what you're arguing?
That is certainly kind of at the core of our claim. And it might be helpful for the court for me to outline exactly what the trust assets would be distributed as if the trust is terminated without additional intervention or change. And so the first piece that Trust 2 and Trust 4, that if the trust is terminated as is, my clients would receive 16 2/3% membership interest in the Inn at Newport Ranch LLC. This is the Inn LLC managing the California Inn on the California coast. This is a business that has lost money every single year since it opened in 2015, save 1 year following receipt of federal stimulus pandemic payroll funds.
Did your client suffer any economic harm as a result of that loss? I thought I read that it was covered by the income beneficiary and the other trust.
So the harm to my clients at this point is the diminished value of their the expected assets.
But the record says it's 120 million. That is a large gain over what it originally was.
So two small corrections on that. One small one. It's 120 million was the value that was referenced frequently by the appellees. But the error in even looking at that value is reflective of the error of the Superior Court and, in fact, Willard Jackson's management of Trust 2 and Trust 4. The 120 value includes a broad swath of asset pools of this Jackson Gruby family asset pool, far beyond looking at Trust 2 and Trust 4, which is what this case is about. And so the error of looking at that global asset pool in order to assess Mr. Jackson's conduct as trustee of Trust 2 and Trust 4 is where the Superior Court went wrong to misapply the legal standard. And it's because Mr. Jackson owed duties. He owes the duty of loyalty to the beneficiaries of Trust 2 and Trust 4. And by his own admission, repeatedly throughout all the trials, and indeed the Superior Court recognized it, he didn't manage Trust 2 and Trust 4 for the benefit of its beneficiaries. He managed them with a global outlook for all the Jackson and Gruby family members.
A couple of points there.
Sure.
The consolidation or the use of pooled assets for investment purposes allowed the trust to access investment vehicles that it otherwise would not be able to access. Is that correct?
Yes, Your Honor. And indeed, pooling of the assets is allowed by the trust documents until, sorry to interrupt you.
Secondly, meticulous records were kept as to the interest that each of the various trusts had in the pooled assets. So it's not as if it was all commingled and can't be separated out. As I read the records were quite clear on who owned what or who was entitled to what.
The commingling is not part of our claim as far as the record keeping. The commingling occurred in the management of the trust. And if we go through the entities, the actual assets that Trust 2 and Trust 4 hold, it is going to be impossible for my clients to then separate out their assets upon distribution. And as you'll note, the trust document allows for commingling or pooling so long as those meticulous records are kept until distribution and termination is required. So if we look at what the entity documents allow, which are the only assets of Trust 2 and Trust 4, they have a membership interest in the LLC. And I can go through in detail what that actually grants them beyond their membership interest in a business that is losing money. And so at the time they become vested with that membership interest, they will then be on the hook for any capital contributions that are required.
Can I ask a question? The inn, and this is more of a factual question. I thought I read that the purchase or the building of the inn was discussed amongst everybody, but I'm not sure if that's the end of it. Were there objections made by your clients to that?
There were objections. There's, the family meeting minutes over the years were part of the record before this court and the Superior Court. And there were certainly objections in the general discussion of the inn, what that discussion entailed and what actually happened. there is a huge disconnect. You know, one of the values in the early 2000s projected at what they were going to spend on the inn
Did the
was,
notes though reflect that your clients objected to it?
some of them do, some of them don't.
And did the court find that consent from your clients was not required?
For the actual building of the inn, correct, Your Honor. And just to recognize, the trust documents gave Willard Jackson as trustee broad discretion. We're not challenging what he,
Well, and the trial judge, as a matter of fact, found that he had tremendous experience in this, in investments generally, and that he acted in good faith.
so the error of the trial court in finding those is not a factual error. We're not contesting the factual findings that Mr. Jackson did have experience in investments per se. However, the error was looking at the entire Jackson Gruby asset pool in order to find that Mr. Jackson was operating in good faith. That's not what we're here. We need to find that he was operating in good faith specific to Trust 2 and Trust 4.
But
And to come back,
doesn't the law say that, I've got in my notes here, that the trial court cited Title 14, A 902B for the principle that trustees' management must be evaluated in the context of a trust portfolio as a whole.
I agree with that 100%, Your Honor, but Trust 2 and Trust 4 have a narrow portfolio. What the trial court did was to come back to that number you used initially, that 120 million. That includes at least 40 other trusts, additional assets as part of this Jackson Gruby family conglomerate. It goes far outside the bounds of what we're looking at specific to Trust 2 and Trust 4. And when we look at what Trust 2 and Trust 4 ultimately are ending up with, it is a far cry from what the grandfather intended his grandchildren to receive at the time of trust termination.
Let me ask the question that I think you were starting out with, which was to identify for us what is in the portfolio of Trust 2 and Trust 4. You told us about the 16 2/3% interest in the Inn LLC. There are other components.
Yes. And just to punctuate that, the 16 2/3 membership interest was obtained through use of $10 million funds from Trust 2 and Trust 4. Like the result of the funds used from Trust 2 and Trust 4 specifically were used to build this in. The next thing in the portfolio of Trust 2 and Trust 4 is upon termination, the beneficiaries will become limited partners in the Jackson Gruby Limited Partnership entity, not a global general partnership, but the limited partnership entity. And this entity is managed by one general partner. Initially, it was Willard Jackson, who had full and exclusive power to manage the assets of the limited partnership. He has since named his successor, that is Susan Levine, my client's sister, to be that general partner. Upon the time of trust termination, to back up, the limited partnership was set to expire on December 31st, 2050, which is 25 years from now, which respectively far exceeds the expected time period of these trusts, which is tied to Mr. Willard's life expectancy. The idea that my clients will receive a limited partnership with no option to withdraw or access their capital accounts prior to the termination in 2015 or 2050 is one of the reasons why Mr. Jackson violated the trust intent to distribute the principal and income to my clients absolutely and forever. The final aspect of the Trust 2 and 4 portfolio is the promissory notes, the IOUs, which, and I've seen my time, so I do want to save some for rebuttal, that in the IOUs are essentially unenforceable and were designed to never be paid because they were designed to never come due because they're only come due upon selling of a ranch that was designed to never be sold.
Okay,
Thank you.
thank you. We'll hear from counsel for the appellee, please. If you would, Mr. Langrock, introduce yourself and identify your client.
May it please the court, my name is Peter Langrock. I represent Will Jackson, who is alive who is present right here. He's 96 years old.
Well, thank you very much.
Still active
Yeah.
on the Board of Trustees of Middlebury College. And Your Honor, there are apparently two objections to this, my client's running of the trust. One involves the property in California, the other loves commingling. Under the trust documents, he's entitled to do exactly what he did. He's been extraordinarily successful. He's built these trusts up from $20 million to $120 million, and they've drawn out $30 million in income to the beneficiaries.
Mr. Langwick, the trial court made specific findings about his financial abilities and his cognition skill in being able to do this at his age. He was very specific that he had the skill, ability, and knowledge to make these decisions.
Did you see the statement made by Judge Teachout in the opinion about his abilities, cognitive abilities?
Yes.
Yeah, I mean, he's extraordinary. He's done an extraordinary job. And what this is all about is the two children, two of the beneficiaries have felt that their father lived too long. As simple as that. They want their money now. And they've come up with this. I want to read to you from Exhibit B. If I can find my glasses. Excuse me. This is a letter in 2017 from Ann, and this one paragraph goes about the inn property. The ranch property in the inn is a legacy. I care deeply about this legacy. It's something our future generation can love and enjoy. The ranch has been something we can be proud of, and I'm deeply committed to success. I hope we all are. We have the unique opportunity in building something that is extraordinary. My frequent visits give me a keen sense and understanding of the inn's charms and popularity of guests and recently my own children. I encourage the family to visit the inn and truly see and feel its uniqueness and appeal. Let us work together rather than separately. This is in 2017. In 2021, sue my client. And just think of, they accuse him of dishonesty in the pleadings. Dishonesty, there's not a trace of any dishonesty in the matter. In
Mr.
terms of,
Langrock? Mr. Langro, is the inn losing money? Has it ever made a profit?
excuse me,
Has the inn ever made a profit? Is it losing money?
1 year it broke even.
I'm sorry?
1 year it broke even.
1 year broke.
But there's never, the plaintiffs in this case have got everything they're entitled to under the trust. They talk about what their grandfather's intention is. His grandfather's intention, if they interpret it correctly, they've got every nickel on it. Every change that has been consented to, it's been family meetings. The dynasty trusts, Rhode Island abolished the rule against perpetuity. Some other states have. And they put this thing in, and with knowledge, they protected the generations of this marvelous property for future generations.
And didn't they all agree to do that?
They all agreed, signed.
And they had the opportunity to consult with counsel.
I think in Jeff's case, it was a couple of months before he signed. And I'm sure there's family pressure to say, we ought to do this. If you haven't looked at Exhibit 35, you should. This is a unique piece of property that it's 1.5 miles of oceanfront, 2,000 acres, 1,000 redwoods, ranch lands. And they ran into troubles, but it's so valuable that the California Commission on the oceanfront gave them 8 years before they could get a permit.
But Mr. Langrock, it's held in perpetuity. Is that correct? It can never be sold, correct?
Basically, it can't never be sold, but it remains in the family to make a decision to be sold. It can be sold at any time. But it requires within the grounds, right now it's a 75% figure.
And do the recipients in Trust 2 and 4, the appellants, do they have, I mean, to be sold, they have the right to vote, but it would be, what's the?
If it was sold, they would get their share of cash.
Yeah, but for it to be sold, it is a majority, correct? It's
No,
majority.
75%.
I'm sorry?
75%.
Okay, thank you.
Yeah. And that was agreed to by them. I mean, this is a situation, and the tax consequences, it's sort of like the English country states, where the states are going down the hill because they can't afford the taxes. This is a situation because it was such a valuable piece of property to perpetuate it, the Dynasty Trust did away with some, I'm not the tax lawyer in terms of thinking, but it was a tremendous situation for it. So what we have here is a successful trustee doing a job and making the best investments in bringing together to get high returns, successful in it. Building and putting together, I think it's 9 parcels. That one of the unique pieces of property that Discovery Channel wanted to feature on it. This is the exhibit 35. That the family loved the situation. And 4 years before they bring the suit, talks about this is something that we can be proud of. The fact that my client likes it is they try to hold it against him. But there's nothing wrong with liking what you're doing. God, at least I like practicing law. If that is a fault, then I take blame for it.
Counsel, can I direct your attention to another spot?
Yeah.
Here for a moment. One of the complaints that's been made is the use of the multiple trusts to join those monies together to increase the opportunity to invest in vehicles.
Yep.
Required certain requirements to be
Yep.
met before you could qualify. What's wrong with that?
There's nothing wrong with that. As a matter of fact, it's increased the values of the property. It's carefully accounted for. And as I said, the plaintiffs have got every nickel they're entitled to. If you just read this thing flat on trust, whatever they're entitled to under the original trust, they've gotten. The problem they have is that they would like to get the corpus. And the corpus was never extended to them until Will dies. It's true of the Gruby children as well. They don't get it till he dies. The management, the gentle management of my client has been to increase the growth, to increase the residual beneficiaries rather than himself. Never once has he done anything that is to enhance himself. In terms of the ability of these people to survive outside the trust, he gave them each an income of $170,000 a year. He gave them $1 million on Shelburne Point. Now, these are all things that suggest that he is doing this for his own avenue. There's not a drop of evidence in that. There's not a drop of evidence of incompetence. The only thing in this case is all about is that they want their money now. And he even orchestrated loans to help them with the situation. And,
How many trusts it's 40 separate trusts are involved in the
about 40 trusts, yeah.
40? Do they all have the same language with respect to paying out of the principal to the residuary beneficiary?
There's some differences, but there's none of those trusts. Some of those trusts have been depleted substantially with they were trusts which the plaintiffs had access to the.
But each of those trusts still have the same voting interest in the inn, for instance? They all have the same voting rights?
I can't say that every one of those trusts has an interest in the inn.
Well, the 75% that voting of voters that would be required in order to liquidate the inn and the property. That
It's pro rata right straight through. Every beneficiary has their share going through the various trusts, so there is no disproportionate from those trusts.
Okay.
Yeah. I can get emotional, but I think you've got my position. Thank you very much.
All right. Thank you. How much time does the appellant have, please?
Appellant has 1 minute, 54 seconds remaining.
All right.
Forgive me for talking quickly, Your Honor. So just at the outset, I do want to also highlight that we are directly appealing the award of attorney's fees. I believe we've briefed that issue. I believe there are concessions in the appellee's brief. I'm happy to answer questions, but I do want to make sure we touch on that if you do have questions on that piece. To respond to some of the appellee's arguments, this is absolutely not about wanting money and wanting money now or trying to have trust termination. Despite family meetings, you can see there was not actual input in accepted consent. The record is replete with contentious arguments and letters back and forth between the family members. What this case is about is the fact that the trustee was designed to hold in trust assets designed from his father to move on to his grandfather. And instead of doing that, to allow that transition to happen, he created a complex web. And so the trust assets will now be held only with, or will be received and required to be working with cousins and siblings. And while that sounds like a good goal, or regardless how your honors think about it, that's not what the trust was intended to do. They were intended to be provided trust assets to do with it as they please at the termination of the trust. That is a far cry from where we are.
Can I address a question to the mismanagement issue?
Yes.
If I understood the record correctly here, he has made decisions throughout to target growth rather than income in these trusts, although he would be entitled to the income. Is that an aspect of mismanagement?
So the mismanagement is the global growth, and that's how he was looking at it. When you look at what happened to Trust 2 and Trust 4, that's what we need to focus on, is the fact that they were essentially gutted to support a global growth. When you look at the benefit of the inn, that all of the funds used to spend on the inn came from Trust 2 and Trust 4 and the equivalent 1 and 3. That includes the $16 million that was spent on the inn far is an outsized proportion to the other withdrawals taken when you look at the global asset pool.
Okay.
I
Thank
see
you
my
very
time is
much.
up.
Time
Thank
has
you.
expired. Please call a conclusion of the hearing.
That concludes